Thank you so much, Mr. Chukwuno. I would like to welcome everybody here today and also to introduce the session coordinator for this panel session, Victor Kolawole, who would actually be the one to introduce myself and the rest of the panelists before we then commence the panel session. So Victor, if you may, you can proceed.
Thank you very much to the moderator for your gracious introduction. Good day, distinguished legal practitioners, esteemed delegates, and student advocates joining us from the globe. My name is Victor Kolawole, a law student from Olabisi Banjo University, and it's my absolute honor to serve as your session coordinator for this opening panel session of the virtual ADR in Students Conference. We are privileged to gather a stellar panel of seasoned experts, academic scholars, and accomplished student leaders to explore the dynamic and evolving landscape of alternative risk resolution. Now, introducing the moderator in the person of Betsy Eluku. To guide today's discussion, I would like to introduce our moderator. Betsy Eluku is a final year law student at the University of Lagos and serves as the president of the University of Lagos Alternative Dispute Resolution. She's the dispute chair of the team's coordination committee at Africa in the Mute, a regional representative for the Nigeria at the Mute Alumni Association, and a junior research fellow at the Lex Letter Center for International Law and Comparative Constitutionalism in Africa. Joining our moderator today is an exceptional lineup of legal minds. First, we'll welcome Dr. Adenike Ishon, PhD, a fellow of the Chartered Institute of Arbitrators and the FCIS. Dr. Esson is a seasoned legal practitioner and in-house counsel with over 2 decades of experience managing complex litigation and arbitration matters in the upstream energy sector, currently leading the litigation arbitration portfolio at Anta Producing Limited. She serves as the pioneer chairman or chairperson of the Corporate and In-house Counsel Committee of CIRB UK, Nigerian branch, and she's also a certified corporate governance auditor and adjunct lecturer at the CPEL University of Ibadan, and a member of the body of neutrals at the NUPRC ADR Center. Let's give a warm virtual round of applause to Dr. Adenike Ession. Next, we'll move next we are to honor the next panel in the person of Mr. Isdore Ozuo. Mr. Isdore is the managing partner at Arrett and Brett LLP and a distinguished dispute resolution advocate with extensive experience across commercial litigation, oil and gas, maritime, employment, and international arbitration. He is also the co-author of the seminal text, Civil Jurisdiction of Courts in Nigeria, Supreme Court of Record, published by the LexisNexis in 2024. Please welcome Mr. Isdore Ozuo. Finally, we are pleased to introduce Mr. Ian Irongu. Mr. Ian Irongu is a LLB candidate at the University of Nairobi, having previously studied political science and international relations at Sciences Po Paris. A two-time participant in the William C. Moot, Ian has interned in corporate commercial department at ALN Kenya and completed the prestigious international commercial arbitration course at the Arbitration Academy Paris. Let's extend a warm welcome to Mr. Ian Irongu. With such a distinguished panel assembled, we are guaranteed an immensely rich and insightful session. Without further delay, I will now hand the virtual floor over to our moderator, Betsy Eluku, to commence the session properly. Betsy, over to you.
Thank you so much, Victor, and good morning once again to everyone. This session, again, is titled, Why Start ADR Early? Building a Dispute Resolution Mindset from Day One. For many law students, ADR feels like something to explore later, perhaps after graduation, after the bar. or once you're already in practice. But this session is here to challenge that assumption. Today, we've brought together three voices who each represent different stages and angles of that early engagement journey. We have a very distinguished academic and arbitration practitioner who trains students and hires young lawyers and mentors them as well. A leader in the CIARB Young Members Group, who sees firsthand what separates candidates who stand out in a saturated legal market, and a young practitioner who lived the ADR journey as a student himself through moot court and competition. Together, three of our speakers today will unpack three big ideas: the real cost of waiting, what a dispute resolution mindset really means, and how to turn early exposure into long-term impact. With that, I would now welcome our three panelists, and we will delve right into the questions set out for today. For the first half of our panel session, we would look to the section of why students should start ADR early. And I would like to direct my first question to Dr. Eshon. And the question is, Dr. Eshon, you wear several hats. You are an in-house counsel, you are an arbitrator, you are a fellow at the Chartered Institute of Arbitrators, and also a lecturer. Many students think they can learn ADR later in their careers, but from your experience, what do students miss by waiting until after graduation to start learning about ADR?
Okay, so good morning, everybody, and thank you to the organizers of this conference for inviting me. What do students miss by starting ADR? I will start by saying that I missed the opportunity, unfortunately, to the extent that I didn't learn about ADR while I was in school. And I actually didn't learn about ADR until much later in my career. So for students who have the opportunity, I'll say it's a good one. I recall that last year when I was a keynote speaker at UNILAG's ADR Society conference. I mentioned it, and I was very, very impressed by the fact that university students were already interacting with ADR, International Investment Arbitration. I didn't get to know about that, and a lot of people still don't know about that, so it's a good one. So for students who are not, taking up the opportunities, I think what they will miss is the opportunity to develop a dispute resolution mindset. So if you don't start ADR early, it's not likely that you develop a dispute resolution mindset. It's likely that you instead develop what I call an adversarial mindset. It is not every dispute that must end in the courts. There must be litigation. ADR helps you to, start thinking differently in terms of not who is right, who is wrong, but how do we resolve this dispute in an efficient way, in a commercially sensible way, in a way that meets the business objectives of your clients. That's what ADR does when you start it early. You have that mindset. And apart from that, it gives you opportunity to network, exposure. It also gives you the opportunity to learn. Like you said, I wear many hats, and one of them is a lecture. I teach international arbitration, and to postgraduate students. Now, because some of them did not learn it early, and even it's very difficult to even understand the basic concepts of arbitration, the principles of arbitration. So you have to teach and teach. But to undergraduate students who are already, doing this, learning ADR, speaking at conferences, attending conferences, you've given yourself a very, very good head start. It's like a relay. You have like one lap ahead of you, ahead of everybody when you start it early. And apart from that, ADR gives you the opportunity to develop life skills. Beyond arbitration, there's mediation, where you develop negotiation skills, where you develop skills that will enable you listen, to communicate effectively. All of those things are available to you when you start learning it early. So yes, it's important to start early. And if you have the advantage, it's important to take it on and don't miss the opportunity. I think that's about it. I'll just let it, end here. It gives you, by way of closing, it gives you the opportunity to build critical life skills, emotional intelligence. All of those things come with starting ADR early. Thank you.
Thank you so much, Dr. Eshon. From what you have said, I think our participants should already now be aware that it is indeed important to start ADR early and to build that dispute resolution mindset. And down the line in our panel session, we'll delve further into what exactly a dispute resolution mindset actually is. My next question will be directed to Mr. Isdor. Mr. Isdor, through your leadership in the CIARB Young Members Group, you interact with young professionals trying to break into the market every day. We often hear that legal and professional market is incredibly saturated. Does starting ADR early as a student give a graduate an actual competitive edge when looking for a job? Or is it just a nice to have line on the CV? So what is the market's reality?
Okay, good morning, Betty, and good morning, everyone. Can you hear me, Betty?
Yes, I can hear you, sir.
Okay, thank you very much for the question. That question assumes that the legal market is incredibly saturated, as you said it. But I'm not so sure that it's incredibly saturated. Someone once told me that it's when you want to hire or employ someone that you know that there is a gap in the talent and the numbers out there. So it's not entirely correct that the legal market is incredibly saturated. If anything, let it be. I'm giving hope to all the young members here that it's not saturated. But in any case, I will answer as if it's saturated. So everywhere is there. They are turning out 10,000 lawyers every year, 15,000 lawyers every year. So what does starting early really do for someone in the as a student or someone trying to join? So of course, what you must know is that when you finish your service or before you even do your service, you start applying to firms. The credentials will almost be the same. LLB, BL, although people are quarreling with BL, but you have it there, LLB, BL. So that's what almost everybody will be going out with. So the question is, what is more, right? What do you have more? Then you go to the grade. Oh, 2121, some firms will say 2121. And now 2121, some firms are now requiring first class. So you now see a situation whereby even law school is throwing out so many first class. In the last 10 years, it was not like that. In the last 10 years, in fact, in our assets, I think it was just 4 first class. But now you see a situation whereby you have over 100 first class, 200. So all these people will be applying. So if you look at the grade, the same, you look at the grades, they are the same. So what are you bringing to the table? Why will it take you? So that is where if someone started early as an ADR practitioner, as a student, you have gone for mid-court competition, you've written 1 or 2 articles, they are looking at you immediately. They want to invite you. They want to hear from you because you've distinguished yourself from the rest. That is starting early. That is just the entry point. But beyond getting employment and all that, the truth of the matter is that the court is not the future. That is the gospel truth. I think ADR is the future. When you come to Nigerian legal practice with that court mindset, you get frustrated. You get frustrated. That is the gospel truth because by the time you are getting judgment after 4 or 5 years, somebody is telling you he's going to appeal to the Court of Appeal. You are spending another 10 years. In fact, they're going to now hang the matter at the Supreme Court. You may never get a date until you retire. So there is a lot of frustration. So starting early, building a niche there, yeah, you'll be happier as an ADR practitioner. But beyond that, of course, if you start early, you'll be exposed to institutions like the Charter Institute of Arbitrators. Imagine in your CV, you're writing a student member of CIR. Wow, it's not just something for the CV. It's something that someone will be interested in to say, okay, please, can we speak with you? And beyond that, starting early gives you opportunity to meet those persons that are in the industry, the senior partners. At least we've had the opportunity of speaking with or seeing, let's say, Godwin Omoke said, you're listening to doctors. So you have access to people that actually the decision makers as a student. So imagine when you leave as a student, you can easily discuss with these persons because as the chair, if you listen to the chair carefully, when she gave her the chair of the branch, when she gave her opening remarks, she talked about it's all about networking. So at this stage, you're already networking. We didn't have this opportunity, to be honest. So if you're already discussing with the chair, the people here, by the time you leave the school, it will be easier for you to penetrate the market. I will stop here, but there are so many benefits of starting early. And I say, like today, of course, I know Betty Eliuku, and she has been very efficient in her email correspondences. These are some of the things we people take note of. So thank you very much.
Thank you very much, Mr. Esdor. And while he was speaking, he did mention some opportunities for students that are on the call to take advantage of. The student membership that CIARB offers is one step already. And also a little comfort that the legal markets might not be as saturated as we tend to think. But of course, if we do start early, and that's what we're here to learn. Mr. Ian Irungu, I would direct my next question to you. Ian, coming to you as someone who chose to dive deep into ADR while navigating the intense workload of university. When you look at peers who focused only on the traditional curriculum versus those who actively engaged with ADR early, much like yourself, where do you see the divergence in how they approach complex legal problems?
Good afternoon, Betty. I hope I'm audible for everyone.
Yes.
And good afternoon from Kenya. I understand it's still morning in Nigeria. So basically, I would say that being exposed to arbitration this early in my student journey enabled me to have options. So when you focus on the conventional law path, you go to law school, you do your conventional units such as contract law, tort law, constitutional law, and then the obvious place where you end up is maybe in a law firm or government legal department, and you practice that sort of law. However, arbitration gives you an out. It gives you an exit from that highway into arbitration, which is a field unto itself. And also within the conventional fields, such as, let's say, contract law, arbitration is still there. So, for example, I interned at a law firm and I was in the corporate commercial department where part of the work was reviewing contracts. But simply having a basic understanding of contract law or commercial law is not in itself sufficient. So, for example, as you all understand, most contracts these days have arbitration clauses. Now, if you did not immerse yourself into arbitration or you have not given much thought to arbitration, it's going to be difficult for you to give holistic reviews of contracts or holistic advice on contract situations without understanding arbitration as a dispute resolution mechanism. So I would say the first thing is that it gives you options outside of the conventional law path that people who do conventional law don't have. And second, it also enhances your understanding of conventional law fields such as contract law and commercial law, even if you're not actively arbitrating or actively participating in the arbitration field. So I would say those are the two big differences that you have as an arbitration enthusiast entering the market.
All right, thank you so much, Ian. With that being said, we will now proceed to the second section of this panel session, where we'll be discussing developing a dispute resolution mindset. And I would go back to Dr. Eshon, who had actually alluded to this in response to the first question. Dr. Eshon, from your experience as both a corporate counsel and an educator, do you notice a difference between students who are exposed to ADR early and those who only discuss it or discover it after graduation? And how does that difference show up in practice?
Okay, I would say absolutely there's a difference. And I'll tell you this. For most parts, what we learn or what we learned, and I want to believe it's still the same in the university, is substantive law. So let's even start with that. It is when you get to the law school that you do the procedural law. That is when you get civil procedure, get to do civil procedure, get to do civil and criminal procedure. That is when you get to apply all of the substantive law, contracts law, torts law that you have learned in the university. That is where you get to apply it. But if you're already interacting with memorials, pleadings, hearings as, members of the ADR society, like I said, very good head start. You understand all of those issues even before you go to law school. So there's certainly a difference in terms of what you know, how you support your clients if you're in private practice, and even if you're in-house, we also have clients, the various units that we support, they are our clients. So the kind of mindset you have, that's where you want to solve the problem. Like Leonard Silk Umwaka SAN said, it's not the one that wins the cases, but solves the problems in a commercially sensible way, efficiently, cost-efficient manner. That is a good lawyer. So that is what ADR, starting ADR early, that is what it does to you. It gives you that, like I said, that opportunity to, put to use all of the skills you have learned. And again, starting ADR early helps you to, take advantage of opportunities with organizations such as CIAB, networking. You have this mediation mindsets. You have opportunities for internship. All of those things help you to be a better lawyer ultimately. And there's certainly a difference in terms of the kind of questions that the student asks in class. In fact, those that start ADR early when they're in your class, you need to be very prepared as a lecturer. If not, you get embarrassed. So I think I will stop there. There's certainly a difference. And if you're working with young lawyers, even whether they are coming in to work in the company, in your legal department, somebody that understands the processes, that understands the issues, you would like to work with the person and you will certainly know them because they understand how arbitration is structured, the difference. In fact, the basic thing is the difference between arbitration and mediation. To a certain extent, it's not known to those that do not, interact with ADR issues or in the community. So starting it early, putting yourself out there, networking opportunities, availing yourself of all of this professional training, it gives you a very good head start. It gives you good opportunity that will also give you a competitive advantage when you want to get a job. Thank you. I'll stop there for now.
Thank you so much, Dr. Eshon. And again, she has mentioned another means by which students can start ADR early, joining ADR societies, getting involved in competitions. That's where you see the opportunities to draft memorials and things of that sort to give you that competitive edge. So I would be directing my next question to Mr. Isdor. And still on the same point, because Dr. Eshon has mentioned how starting ADR early gives you a competitive edge. But from your vantage point in the YMG, Mr. Isdor, what are the biggest behavioral or professional differences you observe between young practitioners who intentionally build ADR skills as students and those who only discovered ADR after entering the workforce? Is there any behavioral or professional differences? And sorry, Mr. Isdor, you're muted.
Oh, okay, sorry. You can hear me now, right?
Yes, yes.
Yeah, so I said to answer your question, the first is that I didn't start early. Let me just give that disclaimer. we had arbitration in school as a course. I never offered it. I ran away from it. I had the book, but what was this all about? I left it. I started my practice without knowing anything about arbitration, ADR. It was when I went for my master's that I took a course on negotiation and mediation, and then I took another course on international commercial arbitration. So that was when I knew that, oh, there's actually something like this going on in the legal profession. So if you say the behavioral differences, I only know my own because the school taught me, gave me the litigation mindset. Of course, you spend how many years studying cases, how you use the principles to the technical points to win the case and all that. So I came from a litigation mindset. From my interaction with YMG, I've only seen one or two persons that actually got trained as ADR. They became associates as students. So one of the things I noticed was that these people already know everybody in the ADR space. Oh, this person trained me. Oh, this yeah, I did my training with this person. So the way they discuss this issue, you get scared that wow, interesting. That you know that you started late. So one of the advantages, as I said again, is that networking. These are the things you notice. The way the network is different from you that is just coming. You're trying to fit in. They're already there because it's possible that they were trained by the persons that you are now trying to get acquainted with and all that. So there, of course, there are differences. However, just to talk on the mindset, uh, I think that mindset, this litigation aggressive mindset is still there, and it will be difficult to go away because of the curriculum we have in schools. We hear about mid-court competition. I don't know. I've not heard about arbitration mid competition in schools or mediation competition in schools. Well, it's possible that that is in place now. If it is in place now, then you guys must be very lucky. When we are there, it was all about courts, and I did it very well. I was the chief judge. In fact, when I was there, I was deeply involved. I wrote the rules of the high court, the Losa High Court rules. I was deeply involved. But imagine some person, if there is something like mute arbitration, uh, mute, and some of you are getting involved in maybe writing the rules, arbitration rules of the high court or of your school, you will see how far you'll be able to go when you come out. It will be surely different. Thank you.
Thank you so much, Mr. Estor. And my next question going to Ian, and it actually touches on what you have said, Mr. Estor. So I'll be moving to Ian, who has actually been actively involved in most of these activities. So Ian, having participated in the VISMUT, which is the largest international arbitration moot competition in the world, and doing this as a student, you experienced the ADR in a highly intense environment. Beyond the advocacy skills, how did grinding through those complex commercial problems change the way you handle conflict? Was there a specific moment where your mindset shifted from I need to win an argument to I need to solve a problem, and that would be a better solution?
Yeah, that was actually one of the most striking features of the Vismut, I believe. And because prior to the Vismut, I had taken part in a couple of conventional litigation moots. And then there was such a big difference in how the Vismut was actually handled, how you were supposed to conduct yourself, how you were supposed to speak. So, for example, the first thing that hit me was that in arbitration, moot court competitions, you are supposed to be seated as opposed to standing at a podium. In litigation moots, you are supposed to speak a lot more softly and slowly, as opposed to litigation, where you are much more vocal, you are much more forceful and aggressive in your oral advocacy. So these were things that were instilled to us by our coach in the very first couple of weeks of the VISMUT when I did the moot. And it was such a refreshing change of pace from litigation moots. And that actually shaped my advocacy style, because doing it for 7 months then instills in you that sort of default posture. So you're always much more calm, you're always much more composed when addressing the opposing party or addressing a tribunal than you would in a litigation moot. And also, something else was that as opposed to litigation moots, we were always coached to try to give practical arguments. So, in as much as you're relying on the law, that this is the provision of the Arbitration Act, this is the provision of the New York Convention, and these are the arguments from the case law. At the same time, you resort to some practical arguments. Tell the tribunal why it is time and cost effective for you to merge these two claims, or for you to consider this an admissibility issue and not a jurisdictional issue. And those sorts of arguments will always speak to an arbitrator or even a mediator more than the strictly legal arguments. So it also shaped how you formulate arguments, because as a lawyer, you're always trained to look at the law, research the law, and then give those strict legal arguments. In an arbitration moot, you are taught not just to look at the law, but also to look at the facts and then try to integrate practical arguments. So try to reach the arbitrator not just through the law, not just through logos in Greek philosophy, but also through pathos and ethos, so that you can it's much more effective and you're much more likely to win a dispute that way. So it definitely changes what your posture is when it comes to dispute resolution. And I think it's something that every law student should try, even if you're not that much into arbitration. Apart from doing litigation moots, apart from writing research papers, do an arbitration moot or a mediation moot, and you'll see the difference. Yeah.
Thank you, Ian. So this is for our students on the call, this is your sign to participate in moot competitions so that you are aware of means through which you can achieve justice. And our keynote speaker, much like Dr. Eshon had also mentioned, had stated the same thing. So as a good lawyer is a lawyer that solves the problem, pursues justice, and makes sure that their clients go away with their dispute resolved in the easiest, most convenient, and likely cheaper means. And that's something that these arbitration moots would do for you. It's a mindset that it helps you build even before you start practicing. Still on the second section on developing a dispute resolution mindset, I will direct my next question to Dr. Eshon. Dr. Eshon, if you could change one aspect of the legal education, and seeing that you are also in the system as a lecturer, if you could change one aspect of the legal education in Nigeria to encourage students to embrace ADR earlier, what would it be and why?
Well, if I could change one, like perhaps to make ADR a compulsory course at the undergraduate level, because of all of the issues that we have highlighted, and more importantly, even from the way Ian has, from his last presentation, you could see that this is somebody that has learned ADR early. So if there's anything I can change, is to make ADR a core and a continuous component of legal education from the undergraduate level, not an optional one that one can opt out from. Like I said, it helps you to develop, critical life skills, negotiation skills, communication skills, problem thinking skills. It helps you to think, commercially, not just, thinking of solving, legal battle. So those are the kind of things that I would like to change. And if possible, also introduce internship that is tied to ADR. There are a number of arbitration institutes, ADR, organizations that, students can learn from. They can intern, they can attend, conferences, attend webinars, attend sessions to learn about ADR. So these are some of the things that, if it was my call, I would like to see introduced. and also make it a bit more, you should like make it like almost compulsory, this moot exercise. And I'll recall, and I'm going to tell the story. When I started my PhD, my supervisor, Christopher Key, at the University of Aberdeen, he was actually one of the co-coordinators of the Vince Moot session at Austria then. I recall that going to his office, I saw he was using a software to map the various legal student teams to different arbitrators. It looked like rocket science. He was using a social um, a software that I can't remember what it was. And I can remember him telling me he was so excited explaining it. That was when I got to know, this was back in 2012, that there was such a competition. And to my mind, I was like, wow, wouldn't it be really nice if, Nigerian universities can be part of this? So it was very, 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 should I say, I found it to be very, how would I put it? It was very pleasing to me when I got to know that we are also participating, but not just participating, we are going far in the competition as Nigerian university students. And that is because you have developed dispute resolution mindset, you are interrogating ADR issues, you're understanding it. So if it was made compulsory, not optional, I would have had the opportunity to learn, and not at old age that I did, and is done too, and it will help us. And like I said, the kind of critical skills that you develop, you need it. And there are certain things that would have done better if we had started early. Thank you. I think I'm going to stop here for now. Thank you.
Thank you very much, Ma. And much like Ian has said, and Dr. Eshwan as well, the VIS moots is one of the best moots for practicing arbitration, learning the skills as well. And we would actually encourage every university to participate in the VIS moot. A number of European universities, a large number of European universities participate, and we have very limited, in comparison, very limited African schools participate. And I think Ian can attest to that as well. So it would be great if more African schools can participate in the VIS, learn about arbitration, build the skills that are needed for a dispute resolution mindset. And before I move to the next question, the last question of this section, I would like to encourage everyone, if you have any questions, this is your opportunity to ask them now, which is the point of this panel session. There is a question and answer icon. There's a Q&A icon on the Zoom call where you can put your questions. I can already see some there, and we would get to them towards the ending of the panel session. But I encourage you to drop your questions right now. Thank you. Mr. Isto, my question to you is, one of the CIARB Young Members Group's primary goal is to support the next generation of ADR practitioners. So if a first-year student approached you today and asked, what is the smartest investment of my time or resources that I can make right now if I want to be an excellent dispute resolver in 5 years? What advice would you give them?
Okay, as I said before, I said that ADR is the way to go. ADR is the future because, in fact, when you when you come to join us, that's when you know that you can get a judgment against maybe a Chinese company, an Indian company. You can't enforce it. Because if you take it to that place, they will tell you the stories that there are no treaties, protocols, or correct or whatnot. But you do arbitration with that same Indian company, Chinese company, take it anywhere in the world and you can enforce it. So ADR is actually the best way to go. So if you say what would be the smartest investment of my time, I think is first, of course, you have to understand the rules and the laws and all that. But beyond that, because you're not just expected to come and read the books, you expect there are other extracurricular activities you're expected to engage in. Devote more time into learning about ADR. As I said, when we were in school, it was all about meet courts, and we did all that. In fact, I remember sometimes lectures will be going on, we'll be in the meet court, having meet court section. And we'll tell the people, if you say there is a lecture, we'll tell well, the school expects 70% of our attendance in classes. So the remaining 30% should be spent in court. So it was that bad. So now, what can you do? Is it possible? I'm throwing that as a challenge to everybody here. If there is nothing like arbitration meets or mediation meets in your school, is it possible to devote your time into developing such a thing? And that will make you if there's nothing like that and you're able to achieve it, your name will be known. Even before you come out, we already know that that is the guy that started ADR Mute in my school. In fact, when he was there, he was the head of the society. He developed the arbitration rules we use in our law faculty, or the mediation rules and before you be in a position to develop maybe arbitration rules to be used in a faculty, you of course you have to know the rules that is applicable mainstream, because that is where you will copy, or at least you get your ideas from. And when you come out, you are already known as someone that is interested in ADR, whether arbitration, mediation, and all that. And you will see yourself going towards that direction. So I will advise one of the smartest investment is it something you can do in school to be known as someone interested in ADR? And if there is nothing for you to do, I will advise you to write at least 1 or 2 articles on ADR. You can even write an article on this conference, post it and share it. You put it on your CV. By the time you are submitting, maybe you want to get a job somewhere, someone is seeing articles and say, this guy can write. We need people that develop thought leadership. Please, let's get him on board. So there are things to do, but if you can't, just the list, just write something. And with AI, oh, it's easier. AI can correct your grammar. So I'll stop here. Thank you.
Thank you so much, Mr. Isdor. And we'll just move into the last section of this panel session before we delve into the questions. We have already a number of questions from the participants, which is a good sign. So the last section would be moving from mindset to practice. And my first question for this section will go to Dr. Sean. Ma, looking back on your own journey, is there something you wish you had started doing earlier that would have better prepared you for the ADR practice?
I wish I had actually even, should I say, engaged with the ADR earlier. Like I said, we didn't have the opportunity while at the university. Law school, there was no specific mention of ADR. We just learned civil procedure and straight into practice. And it was much later in the course of my career as a corporate counsel that I started interrogating, interfacing with ADR issues. So I wish I had started earlier. Now, as an ADR practitioner, an arbitrator, I would say never late. It's never is what's the word? It's
better late than never.
Better late than never. Yes, I wish I had started earlier. But where I am in my journey, I'm grateful. I have learned over the years. There are certain things that one would have done differently. Oh, certainly, even in the course of my career, if I had engaged with ADR and been in the, hobnobbing with, the community much earlier. So I would say that for students who have the opportunity, take advantage of all of the opportunities. And the good thing about it is that most things are for free. You can join CHAB as an undergraduate for free. Sometimes you get free offerings to attend conferences, events. So all of those things that are available to you that can help you learn, get involved, know more about ADR, please take advantage of it. We didn't have such, we didn't see those opportunities as we should have. I didn't see them. And some people did. But beyond taking the courses, you also need to be intentional about developing your practice and ADR practice. Like Isdor has said, write articles, be known, be visible. That is when it will work for you. It's not just taking the courses or being in the ADR society. Lend yourself to serve. Be part of a committee doing something. That is when you will learn. That is when it will be relevant. That is when it will add up. Yes. So for me, I wish I had started early. There are certain appointments I wouldn't have done if had been more knowledgeable about ADR. There are certain appointments I would have done, in terms of maybe expert witness if I had been a bit more knowledgeable. What else can I say? Yes, so there's an advantage, but again, never late than never. And whatever opportunities are available, just take it. Particularly when they are free, you get to attend webinars, conferences, and even while at the conference, you get to win a prize. I recall that last year during the CAP conference, one of your colleagues won a prize. So that's it.
Thank you very much, Ma. Moving to you, Mr. Isto. Looking back at your own respective journeys, and I know that you've actually you've answered this question a little earlier. Looking back at your respective journey, what is the one thing you are incredibly grateful you started doing early? And what is one thing you wish you had started even sooner to prepare yourself for the reality of ADR practice? And I know that you had mentioned a bit of this earlier, but if you could just within a few minutes expatiate on this.
Yeah. As I said, I got to well, I didn't start it, as I said, but it was when during my master's that I took a course on international commercial arbitration that they talked about the Charities for Arbitrators UK, and that we were going to visit them then in London. I said, so that was the how I got to know that. So there is Charities for Arbitrators, and they can actually you can become a member and you can get to resolve disputes outside the courtroom. That was my first interaction. And of course, since then, I started becoming interested. So you can say I started early, if during that master's program, that was nearly 9 years ago now. So, but from what I know now, with the aggressive dispute resolution mindset that we have, I wouldn't have gone so deep into that so much of litigation mindset, because a mindset takes a while for you to uh, maybe shift it. It takes a while to shift your mindset. So, but as a student, if I had the mindset of when you come across a case, it should be issue based in terms of it's not about who wins, but how to solve the problem. I didn't see a case as how to solve a problem. I see it as how do I win this argument? That is the training, to be honest. But shifting that mindset to this is a problem, how do I solve it? And when you want to solve a problem, you go deep into asking clients some questions. What do you really want? Not you have your answers as to how to win. You don't even care about what the client really wants, right? In terms of the issues to be addressed. So it's good that if I started early in terms of you build your mindset over time. It's not something you just wake up and then you have a mindset. And just to speak to what Dr. Shaw said, he talked about most of these things, getting them are free. I will now say I just posted a link to the pan. I think the host can see it. It should be shared to everybody. We are having a free registration for 60 students in the conference in Port Harcourt. Those 16 students, we've not selected them. So if you can use that link, sign up, indicate interest to attend the conference, you may be among the lucky 60 persons that will be given a free ticket to attend the CIAP conference in Port Harcourt. So that is one of the best places to start develop, to even know what is going on. So thank you.
Thank you so much, Mr. Isdor. I think that's a very big opportunity for everybody because a lot of people are already asking, how do I start early? How do I start early? I think attending that might be one major means of starting early, speaking, learning to the conference, and also you get the opportunity to speak to ADR practitioners as well. The final question for this panel session before we go into some of the questions that we have from the audience is for Ian. So Ian, if every student on this webinar leaves with just one reason to begin investing in ADR today, rather than waiting until practice, what would you want that reason to be?
I guess I could sum up the reason as first mover advantage. So, I mean, if you're a student on the call and you are with other students who are also doing law, then there's competition. Now, if you invest into ADR this early, so this is by, for example, seeking opportunities in the ADR space, by being an intern in a boutique arbitration firm, or being a tribunal secretary, or academic opportunities such as writing about arbitration law or moot court competitions that deal with arbitration, then you will already position yourself to future employers once you finish your law school as somebody who has or who is well versed and has at least some competency in arbitration. And this will mean that you're at a better competitive advantage than your peers when it comes to getting into arbitration spaces. I mean, this doesn't mean that if you don't do arbitration related work in law school that you won't get into arbitration fields once you graduate. It's just that it's a lot easier to do the legwork when you're in law school than when you already begin your work and your career. And so you have an 8 to 5. I don't know if it's 9 to 5 in some cases, 8 to 6, 9 to 6. And you are already so swamped with work that you will never get a chance to pursue, improvement opportunities. So if you're doing a 9 to 5 job, then when are you going to, for example, study arbitration on the side? When are you going to do the courses that will get you admitted to associate member status in SIAB? When are you going to find the time to intern or shadow an arbitrator? When are you going to find the time to look for these opportunities or to improve yourself in ADR if you don't do it in law school, where even though you are studying law and you have coursework to do, you still have, I think, flexibility in terms of time to do these things at that time. So you're going to be at an advantage if you start being proactive early during your law school journey, rather than waiting for when you graduate and then you start panicking and then you start trying to get yourself into these arbitration spaces when you already do not have much time or opportunity or space. So I would say competitive advantage is you doing something here in law school now than waiting for later.
Thank you so much, Ian. And that brings us to the end of the questions that we have for our panelists, but we still have quite a number of questions from the audience. Some of them are already being answered. And a lot of them have to do with how students can become accredited practitioners or how they can start early. And just in the interest of time, and I would appreciate if any of the panelists can also comment on this, but our panelists had already, throughout the session, alluded to this as well. You can start early by participating in most competitions, going for conferences, writing articles. These are all the things that they had mentioned during the panel session. So that's how visibility, that this is how you can start early by just applying yourself and doing as many arbitration-related work, competitions, writings as you can get your hands on. But even in that regard, there's a question from Omolara Akim Bowale, and she's asking, we've been encouraged to start building a career in ADR from our undergraduate years rather than waiting until after graduation. However, what practical steps would you recommend for students whose universities do not offer ADR courses, do not have ADR clubs, competitions or even elective courses in the field? How can such students intentionally prepare themselves despite these limitations?
Okay. I would like to answer that. And I'd like to refer all of them to you, Betty Eliquim, who is the president or the chair of the ADR Society. So for all of the students that are here that do not have ADR Society in their universities, please be ready to support them to, set such an association up. And even if they are not still able to, you might also want to have them have a system where they can be adjunct or they can associate with you in one form or the other. So at least they can get the advantage of starting early in a structured format. But beyond the ADR Society, you also, there are several opportunities, webinars, so sign up to the mailing list, be on the mailing list of CIAB, be on the mailing list of other arbitration institutes or organizations that offer free trainings, free courses. It helps, it adds up. Like I said, I don't know if I mentioned this, but it's also important that you keep learning. Even the very experienced arbitrators, they keep learning. We had a webinar yesterday, and our branch chair, who is a chartered arbitrator, she still mentioned it that she has learned a lot. In fact, for every webinar, she always says it. And I believe so, because you learn a lot when you listen, when you participate. So make yourself available to take advantage of any freebies in the space. Thank you.
Thank you, Dr. Sean. And I'd actually like to add to that as well. That our University of Lagos was like that about 13 years ago, before our ADR Society was founded. So we didn't participate in ADR competitions. We didn't have an ADR Society, but then we created one because we saw that there was a gap. So I think that, like Dr. Sean has said, that might be your opportunity. It seems like a limitation, but it could also be an opportunity for you to start off an ADR Society in your university and welcome all of these opportunities for students as well. So this person also has another question directed specifically to Mr. Isto. And she says, you have mentioned that ADR is the future and not the courts. So should law students therefore focus primarily on building a career in ADR from the beginning? Or is it still important to develop litigation skills alongside ADR? She also wants to know whether it's possible to do both.
When I said ADR is a future, I'm not by any means suggesting that the courts will not be there. If you listen carefully to the speech by the Netherlands Komoke, he mentioned that ADR is part and parcel of that justice system, right? The court is there. So when you talk about the justice system, you're talking about the court system and the alternative dispute resolution system. The court will always be there. So it is like the basic thing you should know, right? But when you now want to go further, when you want to go, it would be advisable to look into ADR deeply and not one of those things that is optional, there's nothing to do there. Because if you know something is the future, then you pay more attention to it. It's different from where, okay, the default system is the court, because that is what everybody is coming out with, court system. So whether you like it or not, they are certifying you as someone that is already trained in the court system. So what do you, and you know that this court system is frustrating. In fact, at some point, when you have spent 10, 20 years in court, you're not okay, can we settle and just move on? There's a case, there's a case we just settled, we entered terms of settlement last week. We were in court for about 2 years, no headway. Wanted to, it was problem everywhere. So at the point, parties said, okay, can we now settle and just move on? And we just find the terms and we moved on. So if you don't appreciate ADR at this stage, it will be difficult. So they are complementary, but what will eventually happen at the end of the day is the feature is that most of these cases will go through ADR, and before the court system will come in for enforcement purposes and all that. So I'm not by any means suggesting that we're going to run away from it. It can't even run away from courts. The courts will always be there. Thank you.
Thank you, Mr. Estor. And Omolara, I'm sure that our panelists have answered your question very effectively. We have another question. We have about 4 minutes left. So we probably just answer like a question or two. Someone is asking, and this is from an anonymous participant, can it be a person's full professional job? And they're referring to arbitration ADR. Can it be a person's full professional job or a side professional job?
It can be. I would say it can be. But then you need to be very intentional about building your portfolio. But it can't be. Isa is looking like he doesn't agree.
No. In fact, some persons, they have what they call in River State now, people are beginning to set up ADR centers, and that is their job. That is what they do. In fact, one of us in Port Harcourt is now in France because that was where she specialized in. And so it can be your full-time work. If you want to make it a side hustle, it's okay, but you have to be intentional. Just be intentional about it. I mean, you may now end up seeing that that side hustle will not become the main thing that you are not doing. So, yes. So I agree. I agree.
Thank you so much. Oh, okay, so this would be our final question. Another anonymous attendee wants to know how a young person can build a successful career in ADR through mentorship from ADR practitioners and how to go about getting mentorship opportunities. But I'd also like to add this to another question that someone asked on how to build such mentorship relationships and what students could possibly have to offer to sustain such mentorship opportunities. So I don't know if our speakers have something to say about that.
Okay, so the question is, there are certain times that you get the opportunity. There is a structured mentorship program. Like I am a member of Arbitral Women, and earlier in the year, they had brought out a notice that if you want to join the mentorship program, whether as a mentor, as a mentee, and I signed up. So that is because I'm a member of the Arbitral Women. So if you're in an association and such comes up, you should also take advantage of it, sign up. Again, this is about being intentional. Now, if there is no structured mentorship program, you can always reach out to seasoned practitioners. And I've had to in the past. Some 5-6 years ago, I had spoken with somebody who is an arbitrator, a seasoned one, that I would like to sit in, and he had taken the permission of the parties for me to be a pupil arbitrator. So that is some form of mentorship. Again, it's all in your hands how you want your ADR practice to develop. Mentorship, you can, like I said, structured one or unstructured by you being intentional, asking. If you don't ask, you'll probably not get anybody mentoring you. And so that's it. I would also quickly like to add, there was a question I saw about whether there's FCI and CI, what's the difference, particularly my name. So that's a post-nominal. To be a member of CIAB, you have to do some form of assessment, and you can be an associate, a member, or a fellow. I am a fellow, and that is why I am allowed to use that post-nominal after my name. So if you do the assessment, you can become an associate or a member. If an associate, you'll be ACIARB will be after your name. I hope that clarifies. CIAB is the Institute, Chartered Institute of Arbitrators, UK. We have the Nigerian branch, and it is, a committee in the Nigerian branch that that is organizing this conference. I hope that's provided some clarification.
Thank you very much, Ma. So we actually have a bunch of questions on how students can become accredited, how they can take these courses. So I'd just like to say that I think a number of you are on the WhatsApp group chat that was created. So we would try to answer some of these questions on how to go about getting certified, taking the training courses and things of that nature. So we would get across to you on those on the group chat as well, because we are completely out of time. So I'll just use the 1 minute that we have left to sincerely thank our speakers. It was a very enjoyable session. I think that with the number of questions that we got, I think the attendees would say the same. It was really enjoyable. It was very informative. And I'm sure that everybody's going to leave here wanting to delve into ADR, into arbitration. Some people have already started forming the idea of even creating ADR societies in their universities. And this is the point of this panel session and this conference. So the last thing, so yes, thank you once again to our panelists. I'm indeed very grateful on behalf of CIARB and CIAB Young Members Group. I would like to ask that we take a group photo before we call it.
Yeah, or final thoughts, just 30 seconds, final
Yes.
thoughts from me. Okay. The first is that I'm happy to be here. You guys are leading, this is the maiden edition of this conference. I imagine that in the next 10, 20 years, it will not be online conferences, and people will maybe physical conferences may now maybe biannual or once in 3 years. It's entirely possible. But I'm happy to be here. I want to encourage everybody on this call, all the students here, that don't be scared about the noise that so many lawyers. It's not true. There's always a space for you if you know what you are doing. Just be on top of your game. If ADR is easy for you, then make sure that you know everything about it, that when you come out and you will be successful. There is nothing to be scared about. Just do what you are required to do. Thank you.
Thank you so much, Mr. Isto. So yes, we've come to the end of our panel session. Very exciting. And I would just like to ask that we take a group photograph. So we all already have our cameras on, so we can just smile while somebody takes a picture.
Moderator, with your permission, can I also invite the YMG chair, Madam Abisoye, and the branch chairman, Red Doc, to also put on their videos to join in the group photograph?